Security Guard Training Course, Section 7, Canadian Legal System. Table of Contents. Canadian Criminal Court. 1. Hierarchy. 2. Court Protocol, Provincial, Superior, Federal, Military, and Supreme. 3. Appointment of Judges. 4. Ethics and Review. 5. Court Etiquette. Charter of Rights and Freedoms. 1. Legal Rights, Sections 7 to 10, 11, 12 to 14. 2. Scenario Quiz. PPIDA. 1. Overview. 2. Rights under PPIDA. 3. Where PPIDA applies. Table of Contents continued. Part 4. Employment Standards Act. 1. Overview. 2. Frequently Asked Questions. 3. Complaint Procedure. Part 5. Municipal bylaws. 1. Overview. 2. Examples. Canadian Criminal Court System. The basic role of courts in Canada is to help people resolve disputes fairly and with justice, whether the matter is solely between individuals or between an individual and the state. In the process, courts interpret and establish law, set standards, and raise questions that affect all aspects of Canadian society. It is worth noting, however, that most disputes do not ever reach a court. Most people settle their disputes through alternative methods, although the idea of going to court lingers in the back of their minds. Even when things never get to court, the court influences people's choices and actions. Court decisions provide guidance on what is acceptable conduct and on the nature and limits of the law. Canada's system of courts is complex, just like the society it serves. There are several levels and types of court, and questions of jurisdiction can be difficult to sort out, especially since courts that share the same functions may go by different names. The federal, provincial, and territorial governments pass laws, and they also share the administration of justice. But the relationship is not simple. For instance, the provinces and territories are responsible for providing everything necessary for their courts, from building and maintaining the courthouses to providing staff and resources such as interpreters, court reporters to prepare transcripts, sheriffs, and registry services, to paying provincial territorial court judges. Yet, the judges for the superior courts are appointed and paid by the federal government. Administration of the Supreme Court of Canada and federally created courts is the responsibility of the federal government. Hierarchy. There are 4 levels of court in Canada. First, there are provincial and territorial courts, which handle the great majority of cases that come into the system. Second are the provincial and territorial superior courts. These courts deal with more serious crimes and also take appeals from provincial and territorial court judgments. On the same level, but responsible for different issues, is the federal court. At the next level are the provincial and territorial courts of appeal and the federal court of appeal, while the highest level is occupied by the Supreme Court of Canada. Provincial courts. Each province and territory, with the exception of Nunavut, has a provincial or territorial court. These courts hear cases involving either federal or provincial or territorial laws. In Nunavut, there is no territorial court, so matters that would normally be heard at that level are heard by the Nunavut Court of Justice, which is a superior court. The names and divisions of these courts may vary from place to place, but their role is the same. Provincial or territorial courts deal with most criminal offenses, family law matters, except divorce, young persons in conflict with the law from 12 to 17 years old, traffic violations, provincial or territorial regulatory offenses, and claims involving money up to a certain amount, set by the jurisdiction in question. Private disputes involving limited sums of money may also be dealt with at this level in small claims court. In addition, all preliminary inquiries hearings to determine whether there is enough evidence to justify a full trial in serious criminal cases take place before the provincial or territorial courts. A number of courts at this level are dedicated exclusively to particular types of offenses or groups of offenders. One example is the Drug Treatment Court (DTC) program, which began in Toronto in 1998, followed over several years by Vancouver, Edmonton, Regina, Winnipeg, and Ottawa. The object of the DTCs is to address the needs of non-violent offenders who are charged with criminal offenses that were motivated by their addiction. Those who qualify are offered an intense combination of judicial supervision and treatment for their dependents, drawing on a range of community support services. Provincial courts continued. Youth courts handle cases where a young person from 12 to 17 years old is charged with an offense under federal youth justice laws. Procedures in youth court provide protections appropriate to the age of the accused, including privacy protections. Courts at either the provincial or territorial or superior court level can be designated youth courts. Some provinces and territories, such as Ontario, Manitoba, Alberta, and the Yukon, have established domestic violence courts in order to improve the response of the justice system to incidents of spousal abuse by decreasing court processing time, increasing conviction rate, providing a focal point for programs and services for victims and offenders, and in some cases, allowing for the specialization of police, crown prosecutors, and the judiciary in domestic violence matters. Superior courts. Each province and territory has superior courts. These courts are known by various names, including Superior Court of Justice, Supreme Court, not to be confused with the Supreme Court of Canada, and Court of Queen's Bench. While the names may differ, the court system is essentially the same across the country, with the exception, again, of Nunavut, where the Nunavut Court of Justice deals with both territorial and superior court matters. The superior courts have inherent jurisdiction, meaning that they can hear cases in any area except those that are specifically limited to another level of court. The superior courts try the most serious criminal and civil cases, including divorce cases and cases that involve large amounts of money. The minimum is set by the province or territory in question. In most provinces and territories, the Superior Court has special divisions, such as the Family Division. Some have established specialized family courts at the Superior Court level to deal exclusively with certain family law matters, including divorce and property claims. The Superior Courts also act as a court of first appeal for the underlying court system that provinces and territories maintain. Although superior courts are administered by the provinces and territories, the judges are appointed and paid by the federal government. Federal courts. The Federal Court and Federal Court of Appeal are essentially superior courts with civil jurisdiction. However, since the courts were created by an act of Parliament, they can only deal with matters specified in federal statutes or laws. In contrast, provincial and territorial superior courts have jurisdiction in all matters except those specifically excluded by a statute. The federal court is the trial-level court. Appeals from it are heard by the Federal Court of Appeal. While based in Ottawa, the judges of both courts conduct hearings across the country. The court's jurisdiction includes interprovincial and federal-provincial disputes, intellectual property proceedings, example copyright, citizenship appeals, Competition Act cases, and cases involving Crown corporations or departments of the Government of Canada. As well, only these courts have jurisdiction to review decisions, orders, and other administrative actions of federal boards, commissions, and tribunals. These bodies may refer any question of law, jurisdiction, or practice to one of the courts at any stage of a proceeding. For certain matters, such as maritime law, a case may be brought either before the Federal Court or Federal Court of Appeal, or before a provincial or territorial superior court. In this respect, the federal courts and the Federal Court of Appeal share jurisdiction with the superior courts. Military courts. Military courts or court-martial were established under the National Defense Act to hear cases involving the Code of Service Discipline. The code applies to all members of the Canadian Forces, as well as civilians who accompany the forces on active service. It lays out a system of disciplinary offenses designed to further the good order and proper functioning of the Canadian Forces. The Court-Martial Appeal Court hears appeals from military courts. Its function is comparable to that of a provincial or territorial appeal court, and it has the same powers as a superior court. Judges in the Court-Martial Appeal Court are selected from the federal courts and other superior courts throughout the country. Like other courts of appeal, the Court-Martial Appeal Court hears cases as a panel of 3. Supreme Court of Canada. The Supreme Court of Canada is the final court of appeal from all other Canadian courts. The Supreme Court has jurisdiction over disputes in all areas of the law, including constitutional law, administrative law, criminal law, and civil law. The court consists of a Chief Justice and 8 other judges, all appointed by the federal government. The Supreme Court Act requires that at least 3 judges must come from Quebec. Traditionally, of the other 6 judges, 3 come from Ontario, 2 from Western Canada, and 1 from the Atlantic provinces. The Supreme Court sits in Ottawa for 3 sessions a year, winter, spring, and fall. Before a case can reach the Supreme Court of Canada, it must have used up all available appeals at other levels of court. Even then, the court must grant permission or leave to appeal before it will hear the case. Leave applications are usually made in writing and reviewed by 3 members of the court, who then grant or deny the request without providing reasons for the decision. Leave to appeal is not given routinely. It is granted only if the case involves a question of public importance, if it raises an important issue of law or mixed law and fact, or if the matter is, for any other reason, significant enough to be considered by the country's Supreme Court. Supreme Court of Canada continued. In certain situations, however, the right to appeal is automatic. For instance, no leave is required in criminal cases where a judge on the panel of a court of appeal has dissented on how the law should be interpreted. Similarly, where a court of appeal has found someone guilty who had been acquitted at the original trial, that person automatically has the right to appeal to the Supreme Court. The Supreme Court of Canada also plays a special role as advisor to the federal government. The government may ask the court to consider questions on any important matter of law or fact, especially concerning interpretation of the Constitution. It may also be asked questions on the interpretation of federal or provincial or territorial legislation, or the powers of Parliament or the legislatures. Provincial and territorial courts of appeal may also be asked to hear references from their respective governments. Appointment of judges. Judges are appointed by the federal or provincial and territorial governments, depending on the level of court. To be appointed by the federal government to a superior court, the federal court, or the Supreme Court, a candidate must have been a lawyer for at least 10 years. Judges appointed to provincial or territorial superior courts must also be qualified to practice law in the jurisdiction in question. There are similar requirements for provincial and territorial appointments. In Canada, judges are not required to have any formal training on how to be a judge before they are appointed. However, once appointed, they have access to a range of programs at both the provincial and territorial and federal levels on all aspects of judging, as well as areas of the law. The National Judicial Institute, in particular, coordinates and delivers educational programs for all federal, provincial, and territorial judges. The Institute is funded by both levels of government and regularly offers courses for new judges. Ethics and review. Each jurisdiction in Canada has a judicial council which has general responsibility for promoting professional standards and conduct. The Council for Federally Appointed Judges is made up of members of the judiciary. For provincially and territorially appointed judges, each province or territory has a judicial council, whose members include judges, lawyers, and individuals from the general public. Judicial councils develop policies and codes of conduct to provide guidance for judges. They may even recommend that a judge be removed from the bench if it becomes necessary, though few judges have in fact been removed in the history of Canada. The Canadian Judicial Council, which is responsible for federally appointed judges, consists of the Chief Justice of all the federal courts and provincial and territorial superior courts. It was created by the federal government to promote efficiency, consistency, and good service in these courts. One of the Council's tasks is to investigate complaints and allegations of misconduct on the part of federally appointed judges. If it finds evidence of serious misconduct, the Council may recommend to the Minister of Justice that the judge be removed. The Minister must in turn get the approval of both the House of Commons and the Senate before a judge can be removed from office. The rules of provincial and territorial judges are similar, but they can be removed by a provincial or territorial cabinet. The Council has developed a set of ethical principles for judges designed to assist judges in maintaining their independence, integrity, and impartiality. Court etiquette. Having to appear in court is not a pleasant thought, but if you have to go, familiarizing yourself with the rules and etiquette will help make it a smooth event. The Canadian court system is based on hundreds of years of tradition. Everyday behavior, which is acceptable in the outside world, is oftentimes not acceptable in a courtroom. Unfortunately, common sense will not always help you figure out what goes and doesn't go inside court. The following is a list of some of the important things you should know for court. Punctuality. If your notice says to be in court by 9 o'clock, then unless your lawyer has told you otherwise, be in court by 9 o'clock. The truth is that you may have to wait several hours before you are dealt with. Typically, people represented by lawyers are dealt with first, and then those without lawyers are dealt with in alphabetical order. Sometimes there may be a short court list, resulting in your name being called early. Searches. Many courthouses are now equipped with metal detectors and security staff. You will be searched, much like at the airport. Do not bring pocket knives, lighters, or anything else that may be construed as a weapon to court. If at any point you leave for a prolonged period of time, the search will be conducted again, despite one having already been completed. Court etiquette continued. Court lists. If you check the court list and can't find your name, this doesn't mean that you can leave. Check with the court clerk's office. They will be able to type your name into their computer system and let you know where you have to appear and when. Food. Do not eat, drink, or chew gum in court. If you are caught doing so, you will be asked to leave the courtroom. Headgear. You are not permitted to wear hats and or sunglasses inside the courtroom. The one exception for headwear is for religious purposes. Entertainment. Sitting in a courtroom waiting to be dealt with can be a long and boring experience. Nonetheless, you cannot choose to entertain yourself by reading, talking, listening to a Walkman, cuddling with a loved one, or sleeping. If you are caught engaging in these activities, you may be asked to leave the courtroom. Cell phones and pagers. All cell phones and paging devices must be turned off before entering the courtroom. Court etiquette continued. Intoxication. As obvious as it sounds, do not come to court under the influence of any substance such as alcohol or drugs. Small children. A courtroom is really no place for a small child. If the child disturbs the courtroom proceedings with noise, you will be asked to leave the courtroom. If possible, make arrangements to leave the child at home or bring someone who can wait with the child outside the courtroom. If you must bring a small child, try to speak with either the Crown, the duty counsel, or another court official to see if you can get dealt with first. You will probably be able to garner some sympathy. Standing. Standing in the body of the courtroom is generally not permitted. This usually occurs when there is a shortage of seating. Those standing are usually asked to wait outside and come back when paged. It is best to arrive early and get a seat. Dress. Dress appropriately for court. Casual clothes that you might wear to the office are acceptable in assignment or set date court. If you are going to court to plead guilty or for trial, then formal business attire is recommended, for it is deemed more appropriate. Court etiquette continued. Addressing the court. When your name is called, proceed to the front of the court. The person on the bench will usually be wearing a black robe. If he or she is wearing a green sachet across the front, then he or she is a justice of the peace and must be addressed as your worship. If the person is wearing a red sachet across the front of his or her robe, then he or she is a judge and must be addressed as your honor. When responding to questions, you must answer with words. Do not nod your head or say, mm-hmm. The court reporter must transcribe everything and cannot record physical gestures or sounds that are not words. Before leaving, make sure the judge or justice of the peace is finished talking to you. Also, make sure you know your next date to return to court. Canadian Charter of Rights and Freedoms. Founded in 1982, the Charter is established on the rule of law. It entrenches in the Constitution of Canada the rights and freedoms that Canadians believe are necessary in a free and democratic society. It recognizes primary fundamental freedoms, for example, freedom of expression and of association, democratic rights, for example, the right to vote, mobility rights, for example, the right to live anywhere in Canada, legal rights, example, the right to life, liberty, and security of the person, and equality rights. It recognizes the multicultural heritage of Canadians, protecting official language and minority language education rights. In addition, the provisions of Section 25 guarantee the rights of the Aboriginal peoples of Canada. The Charter regulates interactions between the state, federal, provincial, and territorial governments, and individuals. It is, in some respects, Canada's most important law because it can render invalid or inoperative any laws that are inconsistent with its provisions. For more than 25 years, the Charter has been the driving force of change, progress, and the affirmation of our society's values. Canadian courts have rendered hundreds of decisions in which they invoke the Charter to bring Canadian laws into accordance with the principles and values of Canadian society. The Charter has had a major impact on the promotion and protection of human rights in Canada. With respect to language rights, it has reinforced the rights of official language minorities. With regard to equality rights, it has led to the recognition and enforcement of the rights of a number of minorities and disadvantaged groups. In penal matters, the Charter has clarified to a considerable extent the state's power with respect to offender rights. Legal rights. Section 7. Everyone has the right to life, liberty, and security of the person and the right not to be deprived thereof except in accordance with the principles of fundamental justice. Section 8. Everyone has the right to be secure against unreasonable search or seizure. Section 9. Everyone has the right not to be arbitrarily detained or imprisoned. Section 10. Everyone has the right, on arrest or detention, a. to be informed promptly of the reasons therefor, b. to retain and instruct counsel without delay and to be informed of that right, and c. to have the validity and the detention determined by ways of habeas corpus and to be released if the detention is not lawful. Legal rights continued. Section 11. Any person charged with an offense has the right a. to be informed without unreasonable delay of the specific offense, b. to be tried within a reasonable time, c. not to be compelled to be a witness in proceedings against that person in respect of the offense, d. to be presumed innocent until proven guilty, according to law in a fair and public hearing by an independent and impartial tribunal, e. not to be denied reasonable bail without just cause. F. Except in the case of an offense under military law, tried before a military tribunal to the benefit of trial by jury where the maximum punishment for the offense is imprisonment for 5 years or a more severe punishment. G. Not to be found guilty on account of any act or omission unless, at the time of the act or omission, it constituted an offense under Canadian or international law or was criminal according to the general principles of law recognized by the community of nations. H. If finally acquitted of the offense, not to be tried for it again, and if finally found guilty and punished for the offense, not to be tried or punished for it again. And I. If found guilty of the offense, and if the punishment for the offense has been varied between the time of commission and the time of sentencing, to the benefit of the lesser punishment. Legal rights continued. Section 12. Everyone has the right not to be subjected to any cruel and unusual treatment or punishment. Section 13. A witness who testifies in any proceedings has the right not to have any incriminating evidence so given used to incriminate that witness in any other proceedings, except in a prosecution for perjury or for the giving of contradictory evidence. Section 14. A party or witness in any proceeding who does not understand or speak the language in which the proceedings are conducted or who is deaf has the right to the assistance of an interpreter. Scenario quiz. Read the scenario below. It describes the arrest of an individual by a security guard on duty at a mall. With reference to the Charter of Rights and Freedoms, explain why the actions of the security guard were inappropriate under the circumstances. There will be specific questions related to the scenario in the quiz at the end of the section. Security guard Mike Jones is on duty at his usual site, a retail mall property in downtown Toronto. While on duty, one evening, he sees a known shoplifter in the mall. This man has always managed to escape getting caught, but several store owners have given the same description of this person. Security guard Jones has also seen him before and is almost positive he has found this known shoplifter. As the suspect is seen trying to exit the building, security guard Jones approaches him in order to arrest him. Seeing security guard Jones approaching, the suspect flees in the opposite direction, trying his best to escape getting caught by the security guard. After a short pursuit, the suspect is cornered near a back corridor. Security guard Jones demands to see his identification, but the suspect refuses to provide it and challenges the security guard to prove he has done something wrong. Security guard Jones is certain the man has stolen something, so he grabs his backpack and begins to search it. Sure enough, he finds 3 stolen movies with the price tags still on them inside the backpack. Security guard Jones now has all the evidence he will need to charge the suspect with theft, so he places him in handcuffs and escorts him back to the security office. When the police arrive about 30 minutes later, they immediately release the suspect without charging him and begin to lecture security guard Jones on why his conduct was very inappropriate. PEPITA. When you do business with a company, you do more than simply exchange money for a product or service. Unless you pay in cash, you also leave behind a trail of personal information about yourself. Your name, address, credit card number, and spending habits are all information of great value to somebody, whether that's a legitimate marketer or an identity thief. Without question, many organizations need to collect personal information about you for their legitimate business purposes. However, there are rules to ensure that they advise you about their intent to collect and use your personal information, and obtain your consent. They must also manage your information in a way that safeguards your privacy and lessens the chances that your personal information will fall into the wrong hands. Those rules are set out in the Personal Information Protection and Electronic Documents Act, commonly referred to as PEPITA. In this technological era, it is hard for ordinary people to know when they are being monitored and their personal information recorded, shared, or sold. PEPITA is designed to help you find out and thus to maintain a measure of control over your personal information. After all, control over your personal information is key to preserving your privacy, an important right that is tied to personal autonomy, freedom of thought and speech, and liberty of movement and assembly. PPETA continued. The Office of the Privacy Commissioner of Canada has prepared this overview of PPETA and how it can help protect your privacy. Rights under PPETA. PPETA requires private sector organizations to collect, use, or disclose your personal information by fair and lawful means with your consent and only for purposes that are stated and reasonable. They're also obliged to protect your personal information through appropriate security measures and to destroy it when it's no longer needed for the original purposes. You have the right to expect the personal information the organization holds about you to be accurate, complete, and up to date. That means you have a right to see it and ask for corrections if they got it wrong. If you think an organization covered by PPETA is not living up to its obligations, you should try to address your concerns directly with the organization. If that doesn't work, you have the option of lodging a complaint with the Privacy Commissioner. PPETA continued. Where PPETA applies. PPETA applies to the personal information collected, used, or disclosed by organizations engaged in commercial activities, from banks and retail outlets to airlines, communication companies, and law firms. It applies equally to small and big businesses, whether they operate out of an actual building or only online. The law, which has been fully in force since 2004, applies to private enterprises across Canada. There are exceptions, of course. Many private enterprises operating within British Columbia, Alberta, and Quebec are covered not by PPETA but by similar provincial statutes. Even in those provinces, however, PPETA applies to organizations under federal jurisdiction, such as companies involved in banking, transportation, broadcasting, or telecommunications. For those businesses, PPETA also applies to the personal information of employees. Another law, called the Privacy Act, protects the privacy of your dealings with federal government departments, agencies, and crown corporations. PPETA continued. Examples of personal information under PPETA includes name, race, ethnic origin, marital status, email address, IP address, education level, age, height, blood type, weight, DNA, fingerprints, medical records, income, purchases, financial data, tax returns, SIN number. Employment Standards Act. What is the purpose of the Employment Standards Act, 2000? The ESA sets out the rights and responsibilities of both employees and employers in Ontario workplaces. It also contains provisions that apply to people who are seeking employment with temporary help agencies and, in some cases, to clients of such agencies, even though the client business is not the employer of the person filing a claim under the ESA. What employees and employers are not covered by the ESA? Most employees and employers in Ontario are covered by the ESA. However, the ESA does not apply to certain individuals and persons or organizations for whom they work, including those in sectors that fall under federal jurisdiction, such as airlines, banks, the Federal Civil Service, post offices, radio and television stations, and interprovincial railways. Individuals performing work in a work experience program authorized by a school board, College of Applied Arts and Technology, or university. People who do community participation under the Ontario Works Act 1997. Police officers, except the lie detectors part of the ESA which does apply. Inmates taking part in work programs or people who perform work as part of a sentence or order of a court. People who hold political, judicial, religious, or trade union offices. Employees of the Crown are excluded from some, but not all, provisions of the ESA. For a complete listing of other job categories not governed by the ESA, please check the ESA and its regulations. Regulations set out exemptions to the law, special rules, and details about how to apply certain sections of the ESA. Employment Standards Act continued. Are there rules in the ESA about wage increases? The ESA does not address wage increases. It does provide for minimum wages. The minimum wage rates are set out below. General minimum wage, $10.25 per hour. Student minimum wage, $9.60 per hour. Liquor servers minimum wage, $8.90 per hour. Hunting and fishing guides minimum wage. Rate for working less than 5 consecutive hours in a day, $51.25. Rate for working 5 or more hours in a day, whether or not the hours are consecutive, $102.50. Home workers' wage, 110% of the general minimum wage, $11.28 per hour. Employment Standards Act continued. Are sick leave and bereavement leave covered under the ESA? Employees who work for employers that regularly employ at least 50 employees are entitled to personal emergency leave in certain situations. Personal emergency leave is unpaid, job-protected leave of up to 10 days each year. It may be taken in the case of a personal illness, injury, or medical emergency, or a death, illness, injury, medical emergency of, or urgent matter relating to certain relatives. Family medical leave is unpaid, job-protected leave of up to 8 weeks in a 26-week period. Family medical leave may be taken to provide care or support to certain family members and people who consider the employee to be like a family member, in respect of whom a qualified health practitioner has issued a certificate stating that he or she has a serious illness with a significant risk of death occurring within a period of 26 weeks. Some employers have paid benefit plans for sickness, bereavement, and other leaves of absence. These plans aren't required by the ESA. Must employees produce a doctor's note if asked for one by their employer? An employer is allowed to ask an employee to provide evidence that he or she is eligible for personal emergency leave. The employee is required to provide evidence that is reasonable to the circumstances. If an employee is off sick, can he or she be fired? If the sick day is a personal emergency leave day under the ESA, the employee cannot be penalized for taking the day off. Personal emergency leave days are job protected under the Act. Employment Standards Act continued. Can employees take time off for doctor's appointments? An employee whose employer regularly employs 50 or more employees is entitled to 10 personal emergency leave days per year. Personal emergency leave days can be used to attend a doctor's appointment if the appointment is because of an illness, injury, or medical emergency. This leave is job protected. Do employees have to give notice to their employers when they quit their job? The ESA does not address the issue of employees giving notice to the employer when they quit their job, except under the pregnancy and parental leave provisions, which require that employees give notice to their employer if they are not returning, and in cases where the employer is terminating the employment of 50 or more employees in a 4-week period. Employees may be required to provide their employer with notice that they are quitting under other laws. Can employees choose to take their employer to court for wrongful dismissal rather than filing a claim with the Ministry of Labor? An employee can choose to sue an employer in a court of law for wrongful dismissal. However, an employee can't sue an employer for wrongful dismissal and have a claim for termination or severance pay investigated by the ministry for the same termination or severance. The employee must choose one procedure or the other. Employment Standards Act continued. What if an employee has an agreement to receive more than the minimum requirements set out in the ESA? If a provision in an agreement provides a greater right or benefit than an employment standard, then that provision applies. Can an employee agree not to receive his or her rights under the ESA? No employee can agree to give up his or her rights under the ESA, for example, the right to personal emergency leave. Any such agreement is invalid. What are the rules about dress codes? The employer is responsible for making decisions about dress codes, uniforms, and other clothing requirements. An employer may make a deduction from wages to cover the cost of a uniform or other clothing requirements if the employee has signed a specific written authorization permitting the deduction and setting out its amount. Are employees entitled to discounts on their employer's products? This isn't covered by the ESA. The employer is responsible for deciding whether employees get a discount on products the employer makes or sells, or on services the employer provides. The employer is also the one who determines how much the discount will be. Employment Standards Act continued. What if the employer does not follow the ESA? If an employee thinks the employer is not complying with the ESA, he or she can call the Employment Standards Information Center at 416-326-7160 or toll-free at 1-800-531-5551 for more information about the ESA and how to file a complaint. Complaints are investigated by an employment standards officer who can, if necessary, make orders against an employer, including an order to comply with the ESA. The Ministry has a number of other options to enforce the ESA, including requesting voluntary compliance, issuing an order to pay wages, an order to reinstate and/or compensate, a notice of contravention, or issuing a ticket or otherwise prosecuting the employer under the Provincial Offences Act. Municipal bylaws. A municipal bylaw is a law passed by a city or municipality that exists in that specific region. Bylaws often deal with smaller issues that provincial or federal legislation does not cover. Some examples of these laws include smoking regulations and occupancy limits. While on duty as a security guard, you need to be aware of the relevant bylaws that exist at your site. Keep in mind that bylaws are regional instead of provincial, so if your company sends you multiple sites around the city, there may be different bylaws in place. For example, if you work at a condominium site in Mississauga, the bylaws that exist will not be the same as the retail mall in downtown Toronto you are sent to the next day. Municipal bylaws continued. Below you will find links to various bylaws that exist in the City of Toronto. These bylaws are relevant to situations that security guards would routinely encounter. Keep in mind that there are hundreds of bylaws in every city, and your specific site or company may require you to research and understand additional ones. End of Section 7, Canadian Legal System.